क्या सीरियल नंबर 20
Yes,
आप बोले सेम मैटर
नहीं सेम नहीं वो बोले कि दोनों में टाइम चाहिए इसको 18 और 20 यस मैम बिकॉज टू
आप अपना वीडियो जरा घुमा के देखिए क्या बोले थे
सेम नहीं सेम मैटर नहीं हुआ आईएसएम का एक पुलिस का है दोनों अलग अलग है बस आई प्रेड फॉर टाइम इन बोथ केसेस बिकॉज 2:30 में लेवल कोड 2 में पार्टनर मैटर फिक्स
आप आराम से घर में जाकर YouTube खोल के अपना आर्गुमेंट सुनिएगा और मेरा ऑर्डर भी सुनिए आपके सामने ऑर्डर किए ना विथ किए
सुन नहीं मैम अदरवाइज आई वुड हैव आई एम सॉरी मैम
ऐसे कैसे होता है
माय फॉल्ट टेंडर में both cases are different but I only paid for time
आपकी बातों को ट्रस्ट करने के लिए अब सोचना पड़ेगा
नहीं ऐसा
बिल्कुल सोचना पड़ेगा अब तो सारा रिकॉर्ड जब तक चेक नहीं करेंगे आपकी कोई बात नहीं मानेंगे
नहीं I just prayed for time
You prayed for time, but you said the same matter. वो तो बोल रहे हैं ना आराम से घर जाइएगा YouTube में देखिएगा तब आपको पता चलेगा कि आप क्या बोले यही इसीलिए दोनों विथ भी किए और इसीलिए दोनों एडजर्न भी किए विथ भी किए हैं उसको कौन गया था डिक्टेशन पंकज जी को जरा बुलाइए ठीक है ना डिक्टेशन तक उसी के पास होगा बुलाइए तब तक आप थोड़ा बैठिए
Item 23, Criminal Division 109 of 2019.
In this case, you know, I prayed for some time, you know, I did not search the file, you know. और उसके बाद कोई इंस्ट्रक्शन भी लेना है फॉर आई नो
इंस्ट्रक्शन का कोई काम नहीं
ये एक्सपायर कर गया तो वही हम कंफर्म हो लेते हैं
एक्सपायर कर गया तो किससे कंफर्म होइएगा
उसके फैमिली मेंबर
तो कोई तो बताया होगा ना एक्सपायर
नहीं बताया आउटसाइडर बताया उसके उसी गांव का दूसरा आदमी बताया इसलिए दैट्स व्हाई आई एम नॉट सेइंग लाइक दिस इसको आफ्टर 1 वीक किसी भी दिन रख हम फाइल भी देख लेते हैं होली के बाद किसी भी दिन में पास कर दी
लिखा है कि आपको पता चला ही इज डेड
नहीं
फिर कैसे नहीं लिखा आपको पता चला है ना ही इज डेड एंड यू वांट टू रीवेरीफाई
आउटसाइडर से पता चला उसके गांव का दूसरा कोई है बोलता है कि नहीं वो तो एक्सपायर है फिर उसको भी फोन लगाए लेकिन अभी कांटेक्ट नहीं हो पाया
नहीं होगा ना आदमी जब बेल पे चला जाता है तो कहाँ वकील साहब से कांटेक्ट
नहीं दैट्स ट्रू यू नो तो इसको केवल किसी मेरे ग्राउंड पे दे दे आफ्टर होली किसी
आपके ग्राउंड पे दे रहे हैं लेकिन कोई भी रिवीजन एप्लीकेशन आई एम मेकिंग इट वेरी क्लियर काउंसिल नहीं अपियर होंगे हम एमाइकस अपॉइंट करेंगे हम केस डिस्पोजल
क्यों
हम किसी भी काउंसिल का वेट नहीं करने वाले
क्यों नहीं अपियर करेंगे हम लोग
रिकॉर्ड्स मेरे पास है बाकी हम असिस्टेंस ले लेंगे एमाइकस का और उसके बाद बस हम डिस्पोजल कर देंगे दिन बताइए कौन सा शुभ दिन है आपका
सेकेंड फर्स्ट को खुल रहा है सेकेंड
ट्रिब्यूनल रिवीजन 109 ऑफ 2019 इसका रिकॉर्ड आया है The learned counsel for the petitioner seeks adjournment. The records from the concerned court has already been received and the petitioner is on bail. However, in order to give one indulgence to the petitioner. Post this case on 4th of April under the heading for final disposal. पंकज जी, एक केस में हमने विथ बोला था क्या किसी ने?
जी 18 को 20 के साथ टैग करने को।
ठीक है,
Otherwise, we would have certainly objected because this was not intentional.
I know.
Both the cases are different, and I just prayed for adjournment in April after ruling in December.
दोनों को टैग नहीं करना, डेट दे दीजिएगा. मिस्टर मेहता इज हियर, ही वाज वेटिंग, तभी पता चला.
सेकंड वाला सेम रेटिंग है, फर्स्ट वाला जो था ये रेटिंग वो फाइनल डिस्पोजल में था.
हाँ, सेकंड वाला सेम हेडिंग में है. एक फाइनल डिस्पोजल में गया है और एक सेम हेडिंग.
12 अप्रैल
12.
Item 24, criminal division 110 of 2019.
Yes, petitioner.
Division against equitable lawsuit.
Is it maintainable?
Yes.
Is it maintainable? Revision against acquittal. पता ही नहीं है, यहाँ तो स्टेट काउंसिल को कुछ पता ही नहीं होता. You are for the victim,
Yes. Informant lawsuit.
informant.
Yes.
दो हेल्पिंग ऑर्डर है.
हाँ?
दो हेल्पिंग ऑर्डर है.
Revision against acquittal.
Yes, but two time allowed. Both the court has been rejected.
Both the courts have.
Yes,
Have acquitted.
Yes, ma'am.
Yes, sir.
अब क्या होगा? Revision.
Yes, ma'am.
Revision will lie against acquittal of both the courts.
Yes, ma'am. Because there was no provision of second appeal matter. The first appeal he has already filed for the session court matter. Then allowed the provision line already.
Now they will not. There is no question of any leave now.
Yes, ma'am. And section 372 proviso malord, the victim have right to.
Has already availed.
Yes.
Victim must have availed by filing appeal.
Yes.
कहाँ है आपका?
372 sub clause provision proviso malord, especially stated the victim shall file.
पढ़िए सर. क्या ग्राउंड है आपका?
Lordship. Mechanically see trial court judgment. Para page number 29.
Just a minute.
Paragraph 2, Lordship.
Page number 29.
29 निर्णय 1 में है उपरोक्त निम्नांकित अभियुक्तों को विरुद्ध 498 के भारतीय दंड विधान एवं 3/4 दहेज प्रतिषेध अधिनियम के अंतर्गत आरोप गठन किया गया है. लॉर्डशिप, सूचक का केस संक्षिप्त में है. यह दिनांक 5 मई 2009 को सूचक की शादी कुमार सानू पिता अभिमन्यु महतो मुरुबंदा रजरप्पा जिला रामगढ़ के साथ हुआ था. पिछले 6 वर्षों से इनके साथ मारपीट किरासन तेल से जलाने का प्रयास किया जा रहा है. इनके इकलौते भाई सुभाष कुमार एवं मायके के अन्य लोगों को जान से मारने की धमकियां मिलती रही हैं. जब कभी इनके माता पिता इनको ससुराल पहुंचाने आते थे तब उनके साथ भी इनके पिता मारपीट लाठी डंडा का प्रयोग करते थे। मारपीट करने का मतलब मायके से 1 लाख रुपए और एक मोटरसाइकिल की मांग करते हैं, जिसमें पूर्व में 2,05,000 और बीच में 50,000 रुपए दे चुके हैं, लेकिन अब भी दहेज की मांग जारी थी। इनका एक 4 वर्षीय पुत्र ऋषि कुमार है, उससे इनके ससुराल वाले मारपीट करते हैं। किसी तरह जान बचाकर दिनांक 26/4/2015 को इनके पिताजी इनके मायके लेकर आए, तभी ये अपने मायके में रह रही हैं। उपरोक्त मारपीट में कुमार सानू, ममता कुमारी, पूजा कुमारी शामिल हैं। इनके अलावा महावीर महतो एवं रेणु देवी भी शामिल हैं तथा शिक्षिका के पति दूसरी शादी करने की धमकी देते हैं। लॉर्डशिप, इज द FIR लॉर्डशिप। After FIR lordship, investigation, after completion of investigation, charge sheet has been submitted and trial concludes. 5 witnesses have been examined on behalf of the prosecution lordship. All are supported the prosecution case lordship. May kindly see para 10 lordship, page 31. पांच विटनेस है, पांचों पुलिस सपोर्टेड की है प्रोसिक्यूशन केस।
Who you are for the state?
Yes, sir. Notice.
Notice नहीं हुआ?
वो नोटिस हुआ था, हम लोग नोटिस कर दिए हैं। हुजूर ऑर्डर डेटेड 5/12/2019 का।
नहीं आया। SR of OP number 226 received. Valid SR. नोटिस तो दूसरे रिसीव की है, मदर रिसीव की है, सिस्टर रिसीव की है, रिस्पॉन्डिंग पर्सन। एक का नोटिस है पर्सनली। दिस इज रिगार्डिंग OP number 4। LCR आया है। देखिए, criminal revision 110 of 2019. Counsel for the petitioner and state are present. Admit call for the records from the concerned court. Petitioner is directed to take fresh steps for service of notice upon the opposite parties, which is directed to be served upon the opposite parties through the concerned police station. आप यहाँ फाइल कर दीजिए, पुलिस स्टेशन देकर आए। SR से लोग कोई दूसरा लोग रिसीव कर ले रहे, ठीक है। The service of notice upon the opposite parties, private opposite parties number 226 should be accompanied with the Aadhaar card of the concerned opposite party. The learned counsel for the state is directed to seek instructions from the officer in charge of the concerned police station and file an affidavit regarding service of notice upon opposite parties, party number 226. ये रिक्विजिट फाइल करेंगे, यहीं से चला जाएगा, है ना। आप रिक्विजिट फाइल कर लीजिए।
हमको कम से कम 2-3 सप्ताह का टाइम दिया जाएगा।
आपको टाइम दे देते हैं।
पिटिशनर सभी कंसल्ट, उसका नंबर भी नहीं है, खबर करेंगे सर।
let the requisites be filed by 30th of April. 30 April तक फाइल कर दीजिए.
कोशिश करेंगे 30 अप्रैल तक ये फाइल करेंगे देन
हाँ. Affidavit of service of notice be filed by 17th May. 17th May भी नहीं. 10 जून.
ठीक.
This 11th June. ठीक है? You take your own time. Post this case on 18th of June under appropriate heading.
Item 25, Criminal Division 128 of 2019.
ये सब किस हेडिंग में है? Yes.
Your Ladyship, I have received the Wakalatnama on behalf of the petitioner today itself. Today I have filed it, Your Ladyship. So I was only praying that for proper assistance and for relief and judgment may be. Today itself, by way of notice, I have received the Wakalatnama. Petitioner before Your Lordship is the wife. She has filed a petition for grant of maintenance which was rejected by the Honorable Court.
Rejected.
Yes, ma'am.
On what ground?
That she was not having any sufficient reason to live separately with the husband.
Only on that
Clear
ground
finding.
that has been rejected.
She voluntarily left the company of the husband.
Mr. Vikas Kumar, advocate, seeks adjournment by submitting that he has received Wakalatnama on behalf of the petitioner today itself. Counsel for the opposite party number 2 is present.
If my lord
It is
please-
submitted that the learned court has refused to grant maintenance to the petitioner wife on the ground that she did not have sufficient reasons to live separately.
If my lord pleases, LCR may be called for because entire record has not been filed by the petitioner. I have filed my depositions.
Page 49 and 50 is the review not in the page. Last operative
Office is directed to call for the records from the आगे already.
My lord, may I pray that
Post this case on 7th of April.
My lord, may
Next, 4th of April.
may I pray that access to a copy of LCR may be
Yes, there you can take it.
copy.
Copy we can't give you. Go and get certified copy.
Scan copy.
No.
Item 26, Criminal Division 133 of 2019.
Petitioner.
Item 26.
I have 234 respond opposite party number 234. No,
What is the
opposite
present stage?
opposite party number 2 has expired.
In all the cases.
एक ही case.
अच्छा. What is the present stage of the case?
So she has come challenging the cognizance order. Cognizance has not been taken under 498.
That's right. So what is the present stage?
So,
Cognizance has not been taken at all.
no, cognizance has been taken under
Yes.
323 and 504.
Yes.
Now she is agreed that 498A should also be there.
Yes.
Lord,
Yes.
So, Lordship, in this case, father-in-law has died in this case, so we need some time to take instruction to with petitioner also. Petitioner is, she is a practicing advocate, although she is not coming to this test.
What is the stage of the case? The case must have proceeded.
For which only 1 week time I am seeking for taking instruction.
I have some information, Lord, that after death of opposite party number 2, the matter has been resolved to some extent. Lord. It between the parties. They can say this also. My client has stated that the things are now being resolved. They can.
1 week time.
The counsel for the petitioner and opposite parties have jointly submitted that the father-in-law of the petitioner, who is opposite party number 2 in the present case, has expired. However, the petitioner submits that an appropriate affidavit will be filed to this effect.
ऐसे जो FIR है उसमें 498A का कोई ingredient नहीं है. मतलब her husband is with her. She has no allegation against her husband. Look, quarrel is between the husband-wife and Jade, Devar, and the father-in-law.
The learned counsel for the
कुछ है नहीं.
opposite parties has further submitted that the husband of the petitioner is residing with the petitioner.
हाँ?
And upon death of opposite party number 2, the dispute has almost resolved. ठीक है?
Almost. They can dispute it.
Yes. Because I have to seek instruction.
Okay. To this, counsel for the petitioner submits that he shall seek instructions to this effect also. Let the necessary affidavit in connection with opposite party number 2, in connection with the death of the opposite party number 2, and also the submissions made by the learned counsel for the opposite party number 2 be filed by 3 तारीख तक कर दीजिए, ठीक है? By 3rd of April, post on 4th of April under the heading for orders. अगर mediation में भेजना होगा तो भेज देंगे, है ना? In the meantime, the office is directed to call for the status of the case before the learned court.
झगड़ा था, घर जो बना हुआ है, ससुर का बनाया हुआ घर था, उसमें रूम का झगड़ा है.
कोई बात नहीं.
उनके डेथ के बाद हाँ ठीक है, जो करना है.
नहीं, आप हमको ये बताइए स्टेज क्या है केस का, नहीं पता. ऑफिस
और इस केस में जो है कि 498A जो एलिगेशन ही नहीं.
अरे भाई, तो जिसमें कॉग्निजेंस हुआ होगा तो केस तो प्रोसीड कर गया होगा ना उसमें, या ये नहीं ये गवाही दे रहे हैं, हो सकता है गवाही ना दे रहे होंगे.
हाँ, इसलिए रुका हुआ.
स्टे है. कौन सा इंट्री मॉडल?
स्टे है कि इसमें आएगा. ये तो
स्टे का
498A मतलब हम पे केस है.
हाँ.
हमको दूसरा सेक्शन भी लगाने के लिए केस है. इसमें स्टे.
You are participating in the case. नहीं कर रहे होंगे.
केस इनके द्वारा किया तो स्टे क्यों माने?
नहीं रही तो जाके गवाही नहीं दे रहे होंगे.
हो सकता है गवाही नहीं दे रहे हो क्योंकि मैटर कुछ रिजॉल्व हो.
Office is directed to call for the present status of the case from the court concerned. Let this order be communicated through this.
Item 27, Criminal Division 154 of 2019.
Who is for the petitioner? जब SC/ST का लगता है तो क्रिमिनल अपील फाइल होता है कि डिवीजन फाइल?
बेल में.
बेल में नहीं, और ऐसे
डिस्चार्ज में
रिविजन फाइल. Nobody appears for the petitioner. In order to give one more chance Post this case on 18th of April. In the meantime, the office is directed to call for a report regarding the present status of the case. Let this order be communicated through fax.
Item 28, Criminal Division 174 of 2019.
Yeah. Maintenance application motion with the wife was filed. Jharkhand Lordship has granted allowance of this 3,000 only to the minor daughter, not to the wife, on the ground that it was a second marriage, and during the subsistence of the first marriage, Lordship, marriage was solemnized without taking names. That is the ground, Lordship.
That is good enough.
But since Lordship, there are several judgments on that point. Even in the live-in relations, other things are also there. That has to be seen.
No. For live-in relationship, there is no question of grant of maintenance in this manner.
Whatever submitting, Lordship, I'll be facing those judgments. Only
What do those judgments?
the judgments are there, Lordship. Honorable Apex Court has held in many of the cases that even the strict proof of marriage is not required to be proved, and even for the live-in relations. And Lordship, in this case, the petitioner husband being a constable, even to the minor daughter, Lordship, the amount which is required to be paid. The distress warrant has also been issued by the court concerned, Lordship, but till date, Lordship, not a single farthing has been paid. Now it has sworn up to more than 1 lakh, Lordship, for 44 months.
Where is the opposite party?
We have noticed, Lordship, several times, Lordship, notices have gone. Twice we have served the notice, Lordship.
Chari, 22 squares, 22 squares.
It's deliberately avoiding the court, Lordship.
The learned counsel for the petition has submitted that by the impugned order, maintenance has been denied to the wife on the ground that the marriage was a second marriage. The learned counsel further submits that only rupees 3,000 has been directed to be paid as maintenance to the child. He seeks adjournment to file certain judgments that even in case of second marriage during the lifetime of the first marriage, the applicant second wife would be entitled for maintenance. Post this case under the heading for final disposal on 18th of April, the judgments which the petitioner seeks to rely upon should be filed by 10th.
Lordship.
Item 29, Criminal Division 179 of 2019.
वो एक तो ऑर्डर निकालने बोले तो क्रिमिनल रिविजन का निकाले.
उसका वो एक तो होती है.
Petitioner. Who is for CBI? This is Prevention of Money Laundering Act. Do I have the roster? No. Special Judge PMLA under section 3 and 4 of Prevention of Money Laundering Act. देखिए PMLA का अलग रोस्टर है क्या? Right. PMLA no? For revision also? And criminal revision number 179 of 2019. Office is directed to place this case before appropriate bench as per roster.
Item 30, Criminal Division 199 of 2019.
Yes.
The settlement is going on compromise.
With whom are you compromising?
With Yes, some time.
Time for what? Who is for the informant? Counsel for the petitioner is present. In spite of service of notice. OP number 2 का वकालतनामा है ना? Nobody is appearing. Nobody appears for the opposite party number 2. The learned counsel for the state is present. The learned counsel for the petitioner. चल रही है कोई कॉम्प्रोमाइज की बात कि ऐसे ही हवा में बोल रहे हैं?
उनको भी इंफॉर्मेशन आ रहा है, लेकिन क्या है?
आ रहा है मतलब रास्ता में घूम गया?
आज बात किए थे, इसलिए हम 4 सप्ताह का समय
Learned counsel for the petitioner submits that he has been intimated that some talks of compromise is going on between the petitioner and the opposite party number 2. And accordingly he seeks adjournment. Holds this case on 18th of April 2024 under the heading for final disposal. It will be open to the parties to file any joint petition in the matter. Serial number?
27.
क्या किया उसमें?
18
क्या
status
अब क्या बोलना
Client
चाहते
से कोई contact नहीं है. Perhaps this case has been disposed of by the learned. But to say stage में भी court बहुत
स्टेज ही मांगा.
nobody लिखा गया.
नोबडी तो लिखाएगा ही. चलिए क्या होगा जब डिस्पोजल ही हो गया है तो नोबडी से क्या फर्क पड़ने वाला है? कुछ नहीं फर्क पड़ेगा.
Item 31, Criminal Division 202 of 2019.
This was a matter of Section 138 of Negotiable Instruments Act. Your Lordship may produce the order dated 17th of June 2019. Your Lordship.
Where is opposite party?
Your Lordship, we have issued notices to the opposite party, but before issuance of notice to the opposite party, the parties had entered into a compromise, and thereafter the Even after valid service of notice, the opposite party number 2 is not appearing.
You are enjoying exemption from surrender?
Yes, Your Lordship, we have brought the copy of the agreement which was entered into between the petitioner and the opposite party. Your Lordship, it is in IA for exemption.
But opposite party number 2 is not appearing.
Not appearing, Your Lordship. We have issued notice. The office note shows that notices have been validly served.
Then you have to argue the case on merit. We can't do anything about it.
Your Lordship,
We can't take your compromise filed through affidavit on record. We can't do that. Either there has to be a joint compromise petition between the parties, or you have to argue the case on merits.
Your Lordship, the agreement, settlement agreement is on record, Your Lordship.
So what? We can't do anything about it. Whenever there is a settlement, it has to be joint compromise in the court proceedings. If you go outside and settle, we can't do anything about it.
Your Lordship, I'll take instructions from the client. One date will be given, Your Lordship. If we'll bring the entire payment schedule, Your Lordship, by supplementary affidavit.
That will not serve the purpose, no?
In the last.
That does not serve the purpose. Criminal law doesn't go on like this. If you privately give him money and say that the matter has been settled, and he does not come here and confirm that it has been settled, and you do not file a joint compromise petition, we can't do anything about it.
Your Lordship, one adjournment may be given. Will take instructions from the.
कौन है ये OP number 2 जो यहाँ appear नहीं हो रहे?
Your Lordship,
कहाँ का पार्टी?
Sapan Jamshedpur, Your Lordship.
बहुत फेमस आदमी है, appear होने वाला प्राणी नहीं लग रहा। इनका बहुत तरह का केसेस है। You were also granted time to
Bring on record the payment
70,000.
Yes, Your Lordship.
You have paid it.
We have paid the entire amount, Your Lordship. We have to file a supplementary.
But you have not filed it.
No, Your Lordship. That
You are also equally.
Your Lordship, we are not in contact with the client since
You will
last
not be
2 years.
because you must have run away. If you don't have any instructions, let him surrender and serve the sentence.
Your Lordship, 2 weeks time may be given. We'll try to contact the client.
You are enjoying the order of exemption from surrendering, right?
Yes, Your Lordship.
The learned counsel for the petitioner is present. Nobody appears on behalf of opposite party number 2 in spite of service of purpose. The learned counsel for the petitioner has submitted that there has been out of court settlement which has been placed on record by filing a supplementary affidavit.
Your Lordship, in the IA, Your Lordship, the copy of the agreement was
Which has been annexed along with the interlocutory application seeking exemption from surrender. The learned counsel has also submitted that after taking the money from the petitioner, the opposite party number 2 is not appearing before this court. And the entire payment has been made.
Yes,
However, the petitioner has not complied with the order passed earlier to bring on record the documents relating to payment made to the opposite party number 2. The counsel for the petitioner seeks adjournment. कैश पेमेंट कोई करता है?
Your Lordship, 30,000 was paid at the time of agreement only. It is recorded in the agreement, Your Lordship, and remaining 70.
LCR आया है?
It has not been called.
Post this case on 18th of April 2024. Let the records of the concerned court be called for. Let this order be communicated through fax. The interim order regarding exemption granted to the petitioner from surrendering before the court is extended till 22nd April. Mention नहीं करिएगा तो expire कर जाएगा आपका interim order. In fact, it has already expired, isn't it?
Item 32, WPS 1850 of 2021, along with item 33.
Due to also consideration, this written note for argument is required in this case because two cases, it's an assigned matter also. Because I am relying upon two judgment of the Honorable Apex Court, which is required to see lawsuit because there is a two judgment against me, and my argument is the two judgment which is against me is a judgment in for inquiry. The Honorable Apex Court judgment has not been considered. That all point I will raise in my, so that it will be help to lordship and other party and me also. The specific para of the relevant judgment I will quote. Same matter, exactly same quote.
Pleadings are complete.
Pleadings are complete.
No, we have not. Just a minute. There is just 3093 of 22 is Lal Bihari Singh. In this, there is a division bench judgment. I am only relying on that, nothing else. The division bench judgment, paragraph 37. Just a minute. So therefore, at page 26. Therefore, according to our considered view, the finding recorded by the learned single judge to the effect that the statute approved by the Chancellor on 24/12/1986 will be effective till 26/7/1998 is held to be incorrect. As such, the same is quashed and set aside. The writ petitioner or similarly situated employees could be considered for upgradation in pay scale either on the basis of statute approved on so and so or under the career advancement scheme.
Clear order.
No,
Therefore, this is only submission of
that I will show. That's why I'm asking for that.
What will you show? Show it.
Lordship, then okay, Lordship, I'm ready to argue.
So this particular, you say that this is not covered by this judgment.
This judgment was based on the judgment passed by the Honorable Patna High Court. Exactly same. And simply says the statute for the time-bound promotion is said to be deemed to be repealed because of efflux of the time, because since 85-86 that has not been given effect. I have annexed the judgment of this Honorable Court, which says that since after the 97 was the last statute, and thereafter the state has been created, there was no statute in the state of Jharkhand till 2018 when the Lordship has gone through the UGC regulation 2018 also. In 2018 the statute comes into the picture and there is no promotional avenue. Now there is a direct appointment for the university professor. Or under the caste.
My question is very simple.
Lordship.
Whether the issue is covered by this or it is not covered.
I say, Lordship, the word you have used, deemed repealed, is not covered by this judgment because the judgment of Honorable Apex Court has not been considered where the Honorable Apex Court...
Not considered means wrongly decided then.
The judgment in per inquirium, because the word deemed repealed, there is no word deemed repealed what Honorable Justice M.Y. Vakal has been held in the Supreme Court judgment. That I will rely upon, and on the doctrine of destitute, because which says the doctrine of destitute, which says the only effects of the time, long passage of time, if some statute has not given effect, cannot be said, it cannot be given effect to, and it is termed as a deemed repeal. There is a two judgment to that.
Both the cases are covered by this?
I would submit yes, because the point involved is promotion of an reader to the post of professor. Here also, they are making the same prayer that I should be promoted under this statute, which has been extended. The division bench says no extension cannot be granted. So therefore, I say it is covered. The rest is upon your lordship. Because there is a division bench judgment, he says it is in conflict with other judgments, that's another issue.
The learned counsel for the parties are present. The learned counsel for the respondents has submitted that the point involved in the present case is squarely covered by judgment rendered by this court in LPA number 658 of 2018, decided on 28/9/2022, and has relied upon paragraph 37 of the said judgment. The counsel for the petitioner has submitted that the judgment passed in LPA number 658 of 2018 has not considered a few judgments passed by the Honorable Supreme Court. यही है आपका कहानी?
This aspect has not been taken note by the division bench. That I will argue whatever the order will be.
For the आपका तो यही है.
बस
Long and
मेरा
short.
बस नहीं, बस no other argument.
The learned counsel for the petitioner prays for time to file short synopsis and list of dates, and also the judgments which he seek to rely upon by 4th of April 2024. Post this case under the heading for final disposal on 16th April.
Item 34, WPS 3279 of 2021.
Maybe. In this case, I am praying for note today. My senior was supposed to argue in this case. He could not come to the court due to some health issues. This may be kept on Monday.
Who's your senior?
SC3 already.
SC3 is who?
Srindarapati.
Medical emergency.
He was supposed to come today already. He went to hospital, then from hospital he went to home. On Monday we will argue already.
The last opinion order has been passed by Lord. Then the press short synopsis has been given with annexures not this present annexures.
You have filed your synopsis?
Yes.
You have also filed.
We have filed supplementary count, and after that they have filed the synopsis related.
So it would be best not under the headings capsules of final disposal because pleadings are.
But you let's see one point I have to say. Let's see, in this case, the Biscoman was added as a party, respondent number 7, and no counter is filed from Biscoman.
Biscoman, it is the only the proper party, and the Biscoman is not necessary party.
Since the petitioner was appointed by Biscoman.
Initial appointed and then transfer the service has been transferred to the urban department. I will demonstrate you all this because the Biscoman has left.
But our
service has been transferred within the valid.
But our claim is that he is not our employee. He is not employee of urban development.
He has served the substantial period. Now he got himself retired. Now he is saying he is not my employee.
Well, and counsel for the parties are present. Counsel for the respondents seek adjournment. Pleadings are complete?
Yes, I saw
the counsels have submitted that the pleadings in the present case are complete in all respect. Post this case on 16th May.
Under the heading of final disclosure.
हेडिंग नहीं डिसाइड
अच्छा ठीक है
अगला डेट पे भी आप लोग टाइम ही मांगने वाले हैं जान
नहीं हमारा तो ये हो गया है अब इसमें बस वही जो टेक्निकल ग्राउंड पे बट प्लीडिंग्स आर कंप्लीट एवरी डॉक्यूमेंट एवरी रेलेवेंट डॉक्यूमेंट सो नाउ इट विल कम फाइनल डिस्क्लोजर माय रिस्पेक्टफुल सबमिशन बिकॉज़ प्लीडिंग्स आर कंप्लीट
अंडर द हेडिंग ऑफ फाइनल
ऑलराइट
Item 35, Civil Review 44 of 2022.
What is it?
There are 4 cases were heard together, but only one is coming today. Therefore, in the morning we had also mentioned that the other 3 can also be tagged because we filed review in all the cases. Lordship, in this case, the main ground is that, Lordship, there were 4 cases out of
Then
which...
you give us the case number of civil reviews. You have given? Learned counsel for the petitioner submits that arising out of common judgment passed in 4 cases, 4 separate review application has been filed and only the present one has been listed. The other 3 review applications are civil review number
101 of 22,
101 of 22,
100 of 22,
100 of 22,
and 99 of 22.
and 99 of 22. Office is directed to place all the the aforesaid 3 civil review application along with the present civil review application on 2nd of April. If 2nd is तो tied up matter है ना. On 12th of April, 2024. Notice is required in such cases.
BCCL is appearing, BCCL is appearing.
I'm not unless I get Vakalatama. What is that?
Will you appear in civil review application?
Those civil review applications, because I have received Vakalatama and filed in this.
You are filed in this.
In this, the review application that is before your lordship.
It's a common order, all the cases. It's your choice.
नाम तो आएगा ही, लेकिन I do not have Vakalatama. Without
You file it.
No, unless I get it. Maybe.
So I'll pass an order. You get it.
To accept notice and
The learned
no,
counsel
they
for
do
the
not ask us to
petitioner,
accept notice.
the respondent, the respondent Bharat Coking Coal Limited is represented by Mr. Anup Kumar Mehta. In this case, he is also directed to seek instructions and appear in the other 3 cases, so that the cases are ultimately disposed of.
Copies of APA also.
I'll
The
supply all the copies.
Because
Petitioner
APA
undertakes to serve the copy of the civil review applications as well as the corresponding letters patent appeal.
Because I had to
Mr.
withdraw the LPA
That's
and then
right.
with liberty.
Because there I was not appearing.
I had to withdraw because the Honorable Division Bench said that this is a ground in 2 of the
You want
review.
copy of LP also?
Your lordship may call for it and I should get at least, because what grounds they have taken.
Civil review you will get.
Same it was same grounds.
LPA may.
Same grounds. But
So you
since
give it to me, I'll see it.
I'll give the LPs.
To serve the record, soft copy also? Soft copy se chale?
Soft copy or hard copy?
A copy, just a moment. One copy of all the letters patent appeal as well as the corresponding civil review applications in all the 4 cases to Mr. A.K. Mehta, so that he may take appropriate steps in the case. Post on अभी डेट दिए थे ना?
इसको लगता है कि if your lordship
12th
gives me
April?
last week में देने से third week 12th दिए थे तो एक week और
19th April. And let all the 4 cases be tagged.
Item 36, CRP 3214 of 2023.
For modification of Lordship's order at page 12.
What is the order?
The order ceasing processes under sections 83 when quashed by your Lordship. And the date was fixed for appearance before the ACP. Lordship, may kindly take page 14.
Then what?
On this date, your Lordship could not appear. Thereafter, I filed another CRP for modification. वो कोविड के टाइम पे फाइल हुआ था. So a defect was pointed out regarding spelling of affidavit. The affidavit was filed before a notary public in Bihar. So a defect was pointed out in terms of note 48.
What is the present stage of the case?
Present stage cognizance हो गया है. The investigation is over. The final form has already been submitted. Charge sheet has already been submitted.
The state so far as 82 is concerned, it is 82 or 83?
82, 83 दोनों हुआ था. Both were quashed by your Lordships.
नहीं fresh तो नहीं हो गया?
नहीं fresh नहीं हुआ. Fresh मेरे पास order sheet है certified copy. इसके हिसाब से मेरे पास January 2024 तक का है order sheet. इसमें 82 fresh नहीं हुआ. It is running for appearance. Out of 4 accused, 1 appear करते हैं, 3 appear नहीं करते. The only thing is,
yes.
The only thing is that हमको anticipatory bail apply हम नहीं कर पाए थे. तो हमको थोड़ा सा time मिल जाए तो I will apply for anticipatory bail. All the co-accused persons have been granted anticipatory bail. I will appear.
So 82 होने के बाद आपको anticipatory bail मिलेगा?
नहीं मिलेगा. 82 quash कर दिया. 82 quash करके Lordship has passed an order for appearance before the investigating agency.
So you can go for anticipatory bail.
Yes, Lordship. But then ये था ना कि अगर 23/3/2020 को हम appear नहीं करेंगे तो 82 का order recall हो जाएगा. तो इसीलिए हम ये जस्ट एक मॉडिफिकेशन मांग रहे हैं. 1 महीना आज से 1 महीना का डेट मुझे दे दें. Within that time I will secure anticipatory bail and I will appear before the court. Trial court में हम appear.
आपको तो इन्वेस्टिगेटिंग ऑफिसर के पास आती है.
उस आप तो चार्जशीट सबमिट हो गया.
चार्जशीट आपके अगेंस्ट में हो गया.
सबके अगेंस्ट हो गया. आई एम इंक्लूडिंग माय सेल्फ. और कॉग्निजेंस भी हो गया. No purpose will solve on appearing before the investigating agency. कोर्ट में ही appear करना होगा.
आपको बिना क्वेश्चन किए ही चार्जशीट.
On the basis of that cognizance भी हो गया.
क्या बोलना आपको?
Concerned PP is might be on less Mrs. Nehala Sharma. So I am not aware of whether the processes have been executed or not.
CRNP number 3214 of 2023. Counsel for the petitioner is present. Counsel for the state is directed to seek instructions and file a counter affidavit in the present case. Post this case on 4th April. Counter affidavit 12th April. Counter affidavit should be filed by 10th of April.
Item 37, CRNP 623 of 2024.
The restoration of criminal division number 146 of 2022 dismissed due to non-compliance of the order. One defect has not been complied with, therefore my petition has been dismissed. That is a handwritten type copy of handwritten pen that I have annexed with this petition, and I undertake to file separately in criminal division application.
What? I don't get it.
Due to non-filing of handwritten page type copy, my criminal division has been dismissed. So far other defects are concerned, I have removed one limitation petition and limitation
Criminal
petition.
revision number 623 of 2024. Counsel for the petition submits that this petition has been filed for restoration of criminal revision number 1461 of 2022, which stood dismissed on account of non-compliance of order dated 8/2/2022. He submits that, 2024.
Sorry.
The learned counsel submits that the defects could not be removed within time due to inadvertence. क्या लिखे हैं? Ground?
Only one. Para 6 I have onwards I have stated below.
And the remaining defect was only in connection with filing of certain typed copies. The counsel has also submitted that the petitioner is ready with the typed copies and the criminal revision be restored. Any objection?
No.
Counsel for the opposite party. State has no serious objection with regard to notice तो नहीं हुआ था ना उसमें?
No.
Notice नहीं हुआ था ना revision में?
Only direction.
Defective था.
Yes.
Okay. The counsel for the opposite party state has no serious objection to the prayer and has submitted that the petition remained defective and therefore there was no question of issuance of any notice to opposite party number 2. After hearing the learned counsel for the parties being satisfied with the cause shown by the petitioner for non-compliance of order dated 8/2/2024 within the stipulated time, accordingly, time for compliance of order dated 8/2/2024 passed in criminal revision number 1461 of 2022 is extended till 4th of April. 4 अप्रैल तक कर लीजिए. प्रीएम्प्टिव फिर है, नहीं करिएगा फिर से डिसमिस हो जाएगा. आई डू नॉट नो. 4 अप्रैल तक टाइम देगा यहाँ पे. 4 नहीं 10th अप्रैल तक कर. ठीक है. Till 10th of April 2024. Accordingly, this petition is disposed.
For hearing item 38 as second appeal 110 of 2017.
This is the judgment of reversal. The plaintiff instituted a suit for declaration of title and for recovery of possession. So far as the suit land your lordship is concerned, it is a strip of land 14 feet 6 into 6 by 24. This land strip of land. Here our claim your lordship is that we have purchased it way back in 1968 from Messrs. Bihar Mining, who had purchased it from the original person, Kirji Parmar, way back in the 1954. And the defendants, your lordship, they also have purchased from the Kirji Parmar.
You are the defendant?
Defendants, your lordship,
are you the defendant?
Yes.
Are you the defendant?
No, I'm a plaintiff.
You are the plaintiff. There is an judgment of reversal. Reversal.
Suit was decreed, and the appellate court has reversed and the reasons which were assigned by the from the trial court, those reasons have not been met. This matter was argued on last occasion also. So my lord has
the
said,
reasons of the trial court has not been considered by the appellate court.
This is one of the points which I have mentioned.
What is the point of law which you want to agitate?
My lord has asked me to re-arrange the substantial question. Whether the learned appellate court, being the final court of fact and law, was duty bound to discuss evidences available on record and meet reasons assigned by the trial court before reversing this.
Okay.
whether judgment and decree passed by the learned appellate court stands vitiated for not meeting the reasonings assigned by the trial court. Whether the approach of the learned trial court, appellate court, while reversing the finding of the trial court regarding the title of the plaintiff over the suit land and factum of disposition by the defendant.
If the trial court, the appellate court has not met with the reasons which has been assigned by the learned trial court,
yes,
then the matter has to be remanded.
It has to be remanded.
Primarily,
Ultimately, it has to be remanded. But unless section 100 say it has substantial questions of law.
That's it. This would be the substantial question of law.
Unless they
because
come and
they have not they have not acted as per the provision of law.
yes, yes, but the recent judgment of Supreme Court also says so. It is but 2022 SCC page 91, Mandula and others versus Shamsuddin and others. That the judgment should
2022,
reflect Murada.
2022,
Volume 3 SCC page 90.
page 9.
90.
90.
It is on 41 Malada, order 41 rule Malada.
That's right.
30 minutes. My lord will find that in Para Malad, after a very detailed discussion, the learned trial court discussing everything has concluded at page 31. May kindly have a look on page 31.
There is slight discussion at the end of page number, internal page 13 of the appellate court order. देखिए ये सब जजमेंट डिक्री सब निकलते जा रहा है कैसे होगा
ये ज़्यादा सबमिशंस वगैरह लिखा है जिनका में जो है सो
ये जो फाइंडिंग इन्होंने दिया है
फाइंडिंग पोर्शन
हाँ I find that
11 में भी सबमिशन ही है लेकिन लास्ट में सिर्फ लिखे हैं एक पारा 11 में कंसीडरिंग ऑल फैक्ट्स I find the plaintiff have failed to
no you see para 11 is discussing many things
but लेकिन इनका डिस्कशन जो भी है पारा 11 में
हाँ पैरा 11 में ही है
और पारा 11 के बाद फिर दोबारा से पारा 11 गलती से शॉर्ट पैराग्राफ जिसमें कंक्लूड किया
नहीं पैरा 11 जो इनका इंटरनल पेज 12 में है इसमें तो ट्रायल कोर्ट का पूरा
ट्रायल कोर्ट का कोई ओरल एविडेंस इन्होंने नहीं कंसीडर किया और कुछ सर्टेन जो कि एविडेंस है सिर्फ उसी को ही कंसीडर किया जबकि हमारा जो कि ट्रायल कोर्ट का जजमेंट है इट्स अ वेरी एलॉबरेट जजमेंट और ये इनका जो भी स्टैंड वगैरह है उन्होंने इसको कंसीडर किया था और वो कोई भी oral evidence, not a single oral evidence has been taken.
You just now said that the trial court judgment has not been considered at all, which is not correct. He has considered trial court judgment.
Trial court judgment, my lord, this is the relevant material. My lord is aware if a substantial evidence has not been considered, and my lord, even oral materials, my lord, which are material evidence.
Which is that material which has not been considered?
Yes.
Which has a bearing in the matter.
Yes. My lord, मैं कैसी सी my lord it's a trial court. Your lordship, may kindly my lord come to my lord, may kindly see my lord page 42, internal page 9. What were the issues before the trial? And then I will come to find it.
The appellate court also framed the issues.
Only one point he has. No point of determination as such is required. But my lord, there is a substantial compliance to that extent.
Point of determination is required, isn't it?
Is required.
Yes.
That judgment which I have just given, it said that the order 41 to 31 has to be compliant. But one line he has said what is actually to be decided. That I say that is there.
No, he has framed the issues. Para number 4.
Yes, sir.
Para number 4, he has framed the issues. 5 issues have been framed.
No, trial court, not trial court.
Appellate. Yes.
Appellate court has only said
Yes, para number.
On para 10 your lordship mechanics. Para 10 of the appellate court. On hearing both the parties, perusal of records, a careful examination and there are important issues which examine in the light of judgment. In this moot question, point of determination whether the suit land mentioned in point schedule B of the plant is part and parcel of 77 decimals of land purchased by the plaintiff by the sale date dated 18/10/54 and 6/11/1968, or whether the suit land is part and parcel of 98 of this land purchased by the defendant by sale date dated 24/1/40 and the sale date dated 17/11/68. So this point he has framed. I cannot say that there is no point of determination here. Substantial compliance of Order 41 Rule 31 is there. But the way the appeal has been decided, that the very approach of the learned appellate court is perverse. Because oral evidences were considered, and a recent judgment of Supreme Court.
Then the substantial question would be only point number A. Why
Number?
it is, all the questions are relating to point number A only?
Last one is required to be separately framed. Last. C is important. One court, the trial court has said that we are having time at page 31. After discussion of entire oral evidence and all evidence and the cross-examination and their evidences also. And it has been reversed.
When you say perverse, you have to point out, no, what material do you want to say?
I'm coming to that. That's what I'm saying. The Lordship may kindly see the trial court.
No, you see, whenever we frame a question, it has to be
Yes,
specific
yes,
that
yes,
this particular
yes,
provision,
yes.
this particular evidence has not been
Yes,
considered.
yes.
Which is that particular evidence you say that the appellate court has not considered?
Yes, oral evidence, I'm saying oral evidence. Not at all a single oral evidence has been taken into consideration by the appellate. My Lord, may kindly see, I am reading out the oral evidence of para 11 of the trial court.
Are you sure that not even a single oral evidence has been considered?
Your Lordship, may kindly see.
No, I trust you.
No, it's not a single. Paragraph 11 is the finding.
Then we can simply frame an issue by saying that whether the approach of the learned appellate court while reversing the finding of the learned trial court is perverse on account of non-consideration of oral evidences. That should be sufficient.
And other material evidence also.
At least
one important document.
And other material evidence. Which material evidence are you talking
there is a
about?
cell deed. That cell deed. In the cell deed, which they are relying the cell deed. In the western portion of the cell deed, the boundary mentioned is Mokir, Chardiwari Mokir. This is what is the written. This has been interpreted by both the courts. One court.
By?
Yes. Chardiwari Mokir means the person who is selling the land. In the person who sold out the land, in his western part, his own land is there. Mokir Chardiwari means the person who sold
his own property.
It is his property. That has been interpreted by the trial court and said on the basis of that, the defendants do not have any claim. And that part has been taken into consideration by the appellate court, and the appellate court said, no, you have to prove your title as such is not genuine.
So therefore, so far as the interpretation of sale deed is concerned, that sale deed, both the courts have interpreted that particular sale deed, isn't it?
Yes.
So how substantial question can be based on that?
Why I am saying so that interpretation of a document is a substantial question. May kindly appreciate a document interpreted by the trial court and the suit was decreed.
Both the courts have differently interpreted?
They are differently.
Where is the, which is that document? What is that exhibit?
Yes, yes.
Which is that exhibit?
Yeah, I'm just.
Exhibit number?
Yes.
Exhibit C.
Exhibit. Exhibit C. My lord is correct. The relevant para, my lord, so far as the trial court, your lordship is concerned, my lord, it's internal page 15 and page 48. The deed predecessor interest of the defendant has purchased 98 decimal out of the plot number 659 with a definite boundary. In the deed, it has been mentioned in the western boundary follows as Paschim Germany Goran Chardiwari Mokir, meaning thereby that the lands of the vendor of the ancestor of the defendant fell in the western side of the purchased land, measuring 98 decimal. In my considered opinion, this suit land is a part of 20 decimals of land belong to the acquired land over which was sold to Messrs. Bihar Mines and later on sold to the plaintiff. Exhibit 1 is the safety disputed by, so that is not. Now, my lord, may I kindly see my lord the appellate court.
Exhibit C has been considered. How do you say that Exhibit C has not been considered?
Page 11, para 11 of the appellate court. It is admitted by plaintiff, my lord. I am reading it in the middle. Did my lord find?
Yes.
It is admitted by the plaintiff that Hilji Paramji Parmar constructed building and the factory over plot number 669 with the compound wall, and is also admitted that in the said deed, western is mentioned as Jameen Varan Chadiwari Moki. So from the fact, it is apparent that the land of the plaintiff with compound wall adjacent to west of 98 decimals of land of defendant, and the burden was on the plaintiff respondent to prove that there exists a strip of land between the land of the plaintiff and defendant, but the plaintiff failed to prove this by oral and documentary evidence. There is a categorical finding by the trial court, Your Lordship, after perusing each and every.
Where is that finding?
Yes. Page 31 of the trial court judgment, Your Lordship, may kindly see.
31.
31. After discussing entire aspects, the learned trial court hold. I hold that the plaintiffs are purchaser of, and if they have brought title to the suit land, and they will be illegally disposed. They were illegally disposed in the 1975. These issues are decided in the favor of the plaintiff and against them.
No, with regard to Exhibit C,
C.
There is no finding.
Yes, I'm reading.
So therefore, your broad proposition that the trial court judgment, the reasons given by the trial court judgment has not been considered by the appellate court should be a sufficient ground. Why do we need more grounds? That itself is a sufficient ground.
That will encompass.
Second appeal number 110 of 2017. Heard Mr. S.K. Sharma, learned counsel appearing on behalf of the appellant, along with, what's your name? Mr. Anshuman Mishra, advocate. After hearing the counsel for the appellant, this appeal is admitted for hearing on the following substantial question of law. Court, whether the learned appellate court, being first court of fact and law, was duty bound to discuss whether the learned appellate court, while reversing the judgment passed by the trial court, was justified in not considering and meeting the reasons given by the learned trial court to decree the suit. ठीक?
Non-consideration of oral evidence should come.
B. Whether the learned appellate court was justified in not considering any oral evidence adduced by the parties. हो जाएगा?
Yes. Record has to be
called. Call for the records from both the courts. Issue notice to the respondents.
Respondent 1 to 2.
There are 11 respondents. For which requisites under ordinary process as well as registered cover be filed by next Friday and Thursday, by next Thursday. Post this case on 17th May, awaiting service report. इसको लगा दीजिए.
For hearing item 39, criminal division 343 of 2020.
15 to 24.
Because the parties have agreed to compromise and the payment shall be made. It was directed to the district today at the time of the interlocutory application. The respondents had to file the terms of the compromise, which was to be brought in before.
Why is it not filed?
It's because of the reason, because petitioner's mother is
A joint compromise petition was to be filed. Because petitioner's mother is serious, so he could not arrive to sign the document. So I have requested the other side that next week or maybe just after reopening, we'll furnish it jointly, the joint compromise petition. And in the meantime, there are likely chances that the payment shall also be made.
Criminal revision number 343 of 2020. The learned counsel for the parties are present. The counsel for the parties have submitted that the matter has been settled, but joint compromise petition could not be filed, and therefore they seek adjournment. Counsel for the petitioner has submitted that the provisional bail granted to the petitioner be extended.
Yes.
Pose this case on 4th of April. Just और लंबा चाहिए?
Let it be in the week commencing 15th, Bharat.
On 18th of April 2024, under the heading for final disposal, the provisional bail granted to the petitioner is extended till 23rd April.
Much obliged.